So welcome everybody. I can't see anybody, but I'm going to assume most of you are here. So obviously this is Surrey Law Society talk. So welcome everybody. This online course is just want to make it aware that it's a number of one of the number of training courses available to Surrey Law Society members, as I'm sure you know. So you can view some of our forthcoming events and training on screen as we move through these slides. So yeah, I should probably explain a little bit about myself for those of you who don't know, and I'll briefly cover it off because I know we're really here to see Kate and listen to all her good information on private client law and all that. So I'll briefly cover it off. Obviously, work with Chadwick Knott, legal recruitment. So I cover the Southeast, hence obviously appearing here on the Surrey Law Society talk. So I do Oxfordshire, Berkshire, of course Surrey, the Sussexes, Hampshire and Kent as well. So quite a big patch. And within that, sort of most of those home counties, and indeed most of my placements last year, and indeed people that I've been speaking with have been private client lawyers. So I think the Southeast and these home counties have a good tie to that area of law. But indeed, the market is and always will be candidate led. So should there be people who aren't private client lawyers who are still interested in exploring the market, you know, I'm always very keen to speak with people. There's always opportunities for those with good skill sets and experience. So yeah, cover all of the Southeast. My details are on there. Feel free to connect over LinkedIn as well. I know some people, you know, reaching out in the first instance over the phone or email is sometimes they want to be a bit more tentative, a bit more risk averse. I get that completely. So feel free to connect with me on LinkedIn. My details are on there. And yeah, hope to see some of you in some in-person events as well. I think one coming up in November. So yeah, don't be a stranger and feel free to connect with me as well on socials. And yeah, we'll move on with this talk. So just wanted to flag a couple of things. So these are the forthcoming training and events, as you can see on here. There's the social event, quiz and pizza, exciting. Now the 28th of November, it's been moved. But again, looking forward to hopefully seeing some people there. There's some more online conferences and courses coming up, some great speakers. So be sure to flag your interest and book in if you are. I just wanted to also just make it aware that should you want to ask any questions during the session, of course, you'll be encouraged to do so. There is, of course, the Q&A box here, so Kate will be happy to answer any questions that you have as she's talking. We would also generally suggest, though, if you do have some in-depth questions that you want to ask Kate, then sometimes it's best left for the end. Obviously, if it is a burning question and you feel you're going to forget it, then put your hand up and we'll try our best to address it. But equally, if you just want to make a note of it, I'll be running a Q&A session at the end where you'll get to ask all those sorts of questions that you want to ask. So attendees, yeah, if you want to raise your hand if you do have a question during the conversation, and then obviously the organisers can then unmute your microphone. There'll be a 5-minute break at about 1 p.m. just to negate any screen fatigue, and just so you can, I don't know, go on toilet break or stretch your legs. So that'll be at about 1. And just as a final note, the course will be recorded and will be made available to members after the event, should anyone have missed it. And also, there will be a feedback form, and these are really important to the SLS so that they can keep putting together really good and interesting talks and know the kind of stuff that its members want to shed light on and want to hear from professional people about. So definitely fill out that feedback form and let them know what else you're interested in hearing about. But moving on swiftly to obviously why we're all here, which is obviously Kate Selway, who's kindly come and agreed to do a talk for us. So for those of you that don't know, Kate has wide-ranging and highly successful commercial and traditional chancery practice. So she's an experienced litigator. She's appeared in a number of high-profile cases and represented numerous government department and agencies while on the Attorney General's panels. She's continually ranked in the Legal 500 and Chambers for her expert knowledge and in particular ability to articulate highly complex matters in relatively straightforward terms, which is no mean feat either. So her core areas of practice are trusts work, including taxation of trusts, all aspects of property, landlord and tenant disputes, wills, probate, administration of estates, charities work, court of protection, and professional negligence. So quite a wide range. and she also undertakes extensive advisory work in all areas of her expertise. So that's a little intro about Kate, but I'm sure no one's better to talk about Kate than Kate, and indeed what she's planning on talking about. So I'll gladly hand over to you now, Kate, if that's all right.
Great. Thank you very much, Will. Thank you for that detailed introduction, reminding me of all my practice areas.
Yeah, well, I did take the notes, so yeah, absolutely, no problem.
10 out of 10. Yeah, 10 out of 10.
Thank you very much.
Okay. I have got at the end some slides and materials that I will be very happy to share. I thought today, given the nature of the talk, what I would not do today is clog up the screen with PowerPoint. I hope I can hold you all with my interesting stories and my voice alone, but rest assured you don't actually need to take extensive notes if you don't want to, because there will be some materials that I will provide afterwards. Let's get going. Make your files bulletproof from post-death challenges. I think this was a topic I think that came to me from Surrey Law Society, so I hope that's indicative of what somebody and all of you want to hear about. It's a great topic to talk about, I must say, and on that subject, I would encourage you to either raise your hand or put some questions in the Q&A. There aren't so many people that it would be impossible to deal with. Hopefully the questions will come in, and I will try to keep my eye on the Q&A box as we go, because I'm going to talk about a number of different things, and it might be that as we move on to a new topic, you might have some questions about the topic we've just been looking at. So don't hold back. Please feel free. I will keep an eye on the chat box, and I know that if anybody actually wants to be unmuted and it's easier to ask the question, then please do. But of course, we can always deal with that at the end as well. Well, yes, post-death challenges. My litigation practice is full of post-death challenges. So perhaps I have a rather skewed view of the world. Although I was doing some reading the other day and did read that there are very approximately, about 10,000 post-death challenges annually. Not all of them reach the door of the court, obviously. A lot will settle. I think there are probably upwards of 200, 250 cases that come to court each year of varying sorts. So maybe my view of the world isn't that skewed after all, because £10,000 is really an awful lot of disputes, and that's much more than it used to be. I think I was asked about why do I think that was. I think the obvious answer is the increase in house prices, the increase in overall values of estates, and therefore more of a battleground for disappointed relatives or disgruntled other halves, etc., to want to litigate trust estates and wills. There we are. Let me tell you. So I'm going to provide you with a toolkit for trouble ahead. I think I'm going to call this talk, the subtitle of this talk. Let me tell you a little bit about my practice, because I think that will place into context where I'm coming from and why I'm talking about the particular subjects that I will be talking about. I do an awful lot of litigation, but I also do drafting and advisory work. So I will often be drafting, when I'm not litigating, draft deeds and trust instruments. So that could be deeds of variation, it could be lifetime trusts, the whole gamut really of private client documentation. So the core of my practice is indeed private client work, probate, trusts, administration of estates, all sorts of trust disputes. I do have a strong tax element to my practice and related professional negligence issues. So when I was pretty junior and I was on the Attorney General's panels, I used to get instructed in a lot of tax work, which I think gradually as you're junior gives you the confidence to take on bigger and more complicated tax work. So I did have a background as a junior in advising and representing HMRC on various tax appeals. And I think as you get more senior and you're asked more about that sort of tax work. So I do a lot of obviously inheritance tax, capital gains tax, stamp duty, land tax, anything related to property really, even a little bit of VAT, although that's not something that's going to concern us today. I think the other point I would like to make at the outset is that I qualified at the bar just as Tellata came into force, so the Trusts of Land and Appointment of Trustees Act in 1996. I started my practice in October 1996, and I think that that had two important consequences. I was a converter from another subject. I studied history, and I did the GLD, and I was studying the GLD a couple of years before the 96 Act came into force. And so at that time, it was still very important to teach practitioners not only about trusts of land, but also settled land. Eek, I hear you cry, settled land. You can put a question in the chat box or put your hand up if you've if you're one of the people that does know about settled land. But increasingly, of course, and shortly after I completed the GLD, as it's now called, they stopped teaching settled land, and they also don't teach unregistered conveyancing anymore at law school either. So the reason why I'm mentioning that, and I won't dwell on it, is because settled land still comes up, unregistered conveyancing still comes up, and making your files bulletproof from those sorts of problems that crop up is difficult, because if you've never studied and in your day-to-day practice you don't come across settled land issues or unregistered conveyancing issues anymore, it can be difficult to spot the pitfalls. So only earlier this year, back end of last year, I had a client come to me, solicitor client come to me. I think I've got settled land here, but I don't really know. Can you help out this life tenant? He's a tenant for life of this property. He's just so fed up with it. He doesn't want to be burdened with it anymore, etc., etc. Anyway, to cut a long story short, I had the great pleasure of telling that lay client that his position was a lot happier than he thought it was. It was a settled estate, and in fact, the consequence of bringing that strict settlement to an end was that he was entitled to the absolute interest in the property rather than merely a life interest. So he thought he was burdened by something very onerous. In fact, he had a property in the West Country worth £250,000. So there are problems that are difficult to see. And I think one of my toolkits for trouble, one of the remedies in my toolkit is not necessarily asking you to spot a settled land or an unregistered conveyancing issue that you're not competent to spot if you've never studied that, but just be aware that these sorts of problems do still exist, and it's always worth getting a second opinion on something like that if it's a pre-1996 settlement. Is my tip in the toolkit. If you're looking at something that's done pre-1996, whilst it doesn't need to set alarm bells ringing, do be aware that it could be one of those sorts of old law type problems. Okay, the overarching themes that I think are relevant here to a situation where one's trying to guard against post-death challenges or spot them before they get too troublesome is two themes that I want to develop throughout this talk. One is, it's pretty obvious, but it's understanding a testator's situation and requirements. So always have that in mind. And secondly, as you're advising or taking instructions from clients who haven't yet died, is identifying, always keep in mind, identifying what future disputes are theoretically possible. So those are the two things that I think are important, an important checklist at the start of this toolkit. I mean, how often have we all heard, I've heard it frequently, how often have we all heard clients say about the deceased, oh, they'd be turning in their grave if they knew that this was happening. Indeed, that's happened to me a lot. And what people never anticipate when they're making their wills or they're trying to provide for the future, they usually don't anticipate what's going to happen after their death, because if they did, they would have done things differently. So this is another way about thinking about those two themes: understanding the testator's situation and requirements, and identifying future disputes. So that's all by way of a general introduction. What I'd like to do, and the way I'd like to develop this talk, and as I said, please feel free to ask questions. I'll do my best to answer them as we go along. There's one obvious point, and I'm not going to dwell on it, but there is an excellent resource. There are a number of excellent resources, but we should all know, shouldn't we, what best practice looks like. There's lots of information available to practitioners, not only in their formative training, but as one develops in practice. We've got CPD, we've got sessions like this, but we should all know what best practice looks like. And I'm not going to spend the next hour telling you, chapter and verse what best practice is in each of the private client areas. I would, however, like to recommend, which I think it's, I've managed to download an online version a number of years ago, and I'm quite happy to share that. I think it's available as a publication now, and it's the Law Society's Wills and Inheritance Protocol, and they produced that in 2013, I think. But it's highly recommended reading, and no doubt superseded and amended and other things have come along in the meanwhile. But if anybody wants to see my scruffy PDF version of that, I'm sure I'm allowed to share it. But I think it is available from the Law Society's online bookstore, I expect. So my version might be shorter than the published version, but it's a great. I often go to it when I get a case where I think the solicitor hasn't followed best practice in something, and it often actually helps with pleading a case against a professional who hasn't necessarily done things as fully as they ought to have done, because it's full of objectives under various topics. So I will just refer to that periodically as we go through things today. Because there are some useful bits that I think bear repeating. Just as a quick example, for example, vulnerable clients. The protocol identifies 4 key obligations. Whenever you meet a client, you should consider whether they're vulnerable in any way, due to disability, learning difficulties, mental health, infirmity, illness, age, bereavement, and emotional distress. There was that case whose name suddenly escapes me a few years ago, where the deceased made a will at a time when she was suffering from what an expert characterized as some form of acute bereavement distress, and that actually led to a finding in the expert's mind of lack of capacity, because it clouded her judgment so severely that she made provision in her will for something that she wouldn't otherwise have done had she not been suffering from this condition. So there are a number of ways in which a client can be vulnerable, and be aware that having a look at these checklists is certainly a way to remind oneself of what best practice looks like. There's other sorts of vulnerability, of course, and I'll touch on some undue influence matters later, but be aware of the potential for financial abuse, and understand your role in preventing and taking action to protect clients who have or may be subject to financial abuse. I think the other thing about vulnerable clients is taking particular care to ensure that they fully understand what services they actually require. They've come to you for a will, but do they need an LPA? The usual sorts of things like that. And of course, that they're able to make informed decisions. You may find that you can't take instructions because you're too concerned about their capacity. And I think the other point that the protocol makes about vulnerable clients is the difference between, on your part as a professional, encouragement and pressure when promoting your services to them. So that, I think, just in a nutshell, is 4 key things you would think about when dealing with vulnerable clients. But of course, it's not all about vulnerable clients, is it? There are also those robust, stubborn, self-opinionated clients too, who you will have, who need entirely different forms of help. You might have, for example, a testator who is very, very keen to make a will in a particular way, and what may be crying out at you is, oh my goodness, there's a 75 Act claim looming because this testator doesn't want to make any provision for X. So your role there is going to be markedly different from what you're going to be saying to the vulnerable client. Here you've got a client who is very far from vulnerable in the usual sense, that they're a victim of their estate could be a victim of their own stubbornness. So all these sorts of things, understanding a testator's situation and requirements is a long-handed route is, what do we think about human nature when you're visiting either someone in their home or they're visiting you? It's understanding human nature, isn't it? It's in understanding what a testator, what situation they're in, and what help they need. So I will have a few more general points, and then what I'd like to do is get into the nitty-gritty of 2 cases in particular. They're chalk and cheese, but they illustrate in their own way a whole host of problems and what one can do about them. So I think there are 2, if we think about as these 2 problems do, estate planning and will drafting, in a general sense, which is a big topic in its own right. There are obviously in the toolkit, there are some obvious things we need to be reminded of. Urgent instructions and attendance notes are 2 key things that stick out in my mind to start with. The protocol is really good, and I think this is the strength of this protocol. It's my version of it is it's about 83 pages, and over half of that is devoted to taking instructions and dealing with clients' wills. I think I'd just like to highlight to you the points on attendance notes. I think in my practice, it's attendance notes which either are the saving grace of the situation or the root of the problem. So in some cases where, we've got a want of knowledge and approval matter, could be capacity, could be undue influence, but those sort of key will challenge causes of action, the attendance notes have sometimes been absolutely superb, and that's made it really difficult for challenges to wills to get off the ground, and the litigation has, we've managed to squash it, we've settled it at mediation, whatever. So one can't emphasize enough the importance of the brilliant attendance note. what you should be doing, just as a reminder, is making detailed and contemporaneous records of a number of issues. And I don't know whether in-house you have your own checklist as to what you ought to be including on that attendance note. I'm sure you do. But if you don't, what a great idea to be able to have a checklist for an attendance note, because you will want to be thinking about domicile, for example. You'll want to be thinking about, obviously, assets, that's pretty obvious, including those that won't pass by the will. You'll want to be thinking of liabilities. You'll want to be thinking of clients' family tree, whether they have any dependents who aren't related. All with in the back of your mind, obviously, is what provisions should be being made for them in the will, if any, whether a testator understands the needs of and the call upon their generosity that certain beneficiaries might have, and of course with the 75 Act claim in the background. Your attendance note should obviously detail any advice given. They should obviously detail the client's testamentary wishes. One thing I don't see enough of in my practice, and again, I think this is because I end up with the problems once it gets to litigation, but one thing I don't see enough of in practice is discussions of previous wills, because it often happens, doesn't it, that in the problem cases, the client will change solicitors. Maybe they've been forced into doing so. Maybe they've just changed under their own volition. But what can be problematical afterwards is the family saying, well, they'd have never voluntarily done that. They've changed their will. There must be something wrong with it. So I think one important thing that I personally would like to see more often in solicitors' attendance notes is discussions of the earlier will, why they're changing, why they're coming to a different firm of solicitors. Maybe the previous firm was simply too expensive, but an exploration and an attendance note of those sorts of things. Obviously, in your attendance note as well, it may be appropriate, and we'll come back to the golden rule later on, but it may be appropriate to consider specifically testator's capacity and or who brought them there, whether they're potentially going to be subject to some sort of undue pressure or coercion. Preserve that attendance note as part of the will file, obviously, and if they visit you more than once, obviously there should be a collection of attendance notes. So that is one thing I think. If there's one thing I've noticed in the cases that I have come across, it's the problems with the attendance note. I think in relation to urgent instructions as well, that's another problem area I just wanted to concentrate on, because this can be ever so difficult, can't it? There's a fine line to be drawn between doing something because it's urgent, but of course then still taking the trouble to make the full note. I think there's also, before I get on to the urgent bit, there's also a practical consideration, isn't there, that the more detailed you are, the more notes you make, the more thorough job you do, potentially the more expensive your services are going to be. So again, you as practitioners have a line to draw between, on the one hand, doing everything perfectly and in great detail, and the client saying, yeah, but actually this is so simple. I want to leave everything to my daughter, and what's the problem? Why do we need to jump through all these hoops? So no doubt you'll have navigated your own in-house procedures there, but ultimately, one, I think, from a professional perspective, needs to err on the side of a fuller attendance note rather than a skimpy one. So urgency and non-face-to-face instructions. The protocol has actually got some really good points on this, so do have a look at that. But you've obviously got to have your own checks and balances if you are going to take non-face-to-face instructions. How are you going to mitigate the possibility that the testator might be being manipulated behind the scenes? All right, well, with that general overview in mind, let me talk to you about two of my cases, big to small. We're going to start off with I've renamed in this first case. I've renamed all the parties, changed all the dates, because it's something that's still ongoing, and that's the right thing to do. So I've called it the Western settlements. This is a salutary tale of a testator who changed solicitors, and it's a story really of how the most basic of mistakes can lead to an avalanche of problems. And we'll get onto that in a minute. The other case I want to talk to you about is actually a reported decision, one of my cases that was in the first tier tax tribunal, but it's really interesting in a number of respects. For the purpose of this talk, one of the reasons it's interesting is because the solicitor didn't really do too much that was wrong. He could have done something slightly differently and it would have avoided all the problems, but it's another salutary tale really of a case where the testatrix didn't want to pay very much for her will, and things didn't go according to plan. So we've got the aristocracy on the one hand, and we've got a lady called Mrs. Raboni, a lovely Italian retired cafe proprietor that I'll talk to you about after I've talked about the aristocracy for a bit. So let's turn to the Western settlements. I'll tell you a little bit about, first of all, the potential cause of action, because this is a solicitor's negligence case. And the reason for mentioning settled land earlier on was this isn't a settled land case, but it was at one point in the history of this family. So the cause of action is breach of a retainer made between solicitors and the late testator. He's passed away now. From the time of drafting his will onwards until he died, because the solicitors were retained to provide general estate planning advice and also to help him with his will. And he was a member of the landed aristocracy, as his forebears had been and as his children and grandchildren now are, and owned a lot of land. And originally, as you can probably imagine, going back pre-1925, and indeed for a little bit after that, the land was settled property under various old settlements. What I'll do first is run through really quickly what the truth situation was, and then I'll tell you how badly things went wrong. So there was an old 1895 settlement, and after the death of the second Baron, just before the First World War, the third Baron became the tenant for life of this old settlement. And by what's called a vesting deed, executed by the Settled Land Act trustees, the third Baron became the legal proprietor of the trust property, because that's what's happened. That's what usually happens in settled land. You become the legal proprietor and you've got some Settled Land Act trustees in the background. And then he died and the fourth Baron became tenant for life, and he executed another vesting deed in 1931 and he became the tenant for life of the Settled Land Act Trust. What he decided to do was he decided to bring that old settlement to an end in the 1960s, and he did, and he executed a deed of discharge, and that settlement came to a complete end. And later on, following year, he created a new settlement, and that wasn't a Settled Land Act settlement. It was an entailed settlement, so pre-1996 settlement. It created a trust for sale of trust property, but it was entailed. So they held the trustees held the trust property in tail male. You might have heard that old expression. So for the eldest male sons. And eventually we got the fifth Baron, John, who came to enjoy the life interest in this property. But what he did in 1997 was that he did what's called barring the entail. So he brought the entailed settlement to an end, and this was just after the Trusts of Land Act came in 1996, and they evidently thought at that stage, let's make life much simpler. Let's just have a life interest, remainder to my son, Tom, absolutely. So that is a very potted history of this 100-year-old trust. So after, at all times from 1997 onwards, you don't have to worry about the old law. We simply had a situation where John was the tenant for life. The entail had been barred, so when John died, everything was going to go to his son. Not very inheritance tax efficient, was it? Because it doesn't make use of the spouse exemption. So that's the background to it. And I'm going to tell you what John did in a minute, but let me just cut to the chase and tell you when he died. He died, all dates changed. He died in February 2022. So what would have happened on that date is he having been the life tenant, property goes to his son, Tom, absolutely. So that's the history of the trust. But of course, that's not the entire history, because what John decided in about 2014, he decided that, in fact, he'd go and see some new solicitors. The partner, I think, in the old firm that they'd used for years had retired, and he thought, oh, well, I probably need to make a connection with a new firm of solicitors. So he did. And with his son, Tom, they went to see a new set of solicitors. And the problem was that, for reasons that are, when you look at it with hindsight, very obvious, they failed to make themselves aware of the complete history of the trust documentation, notwithstanding that the old solicitors sent them 4 boxes of trust papers. So what John said to and his son Tom, they've had a meeting with the new solicitors, and they said, oh, Lynn, we've got as only the aristocracy can, we've got a few family trusts knocking around, so we want you to take charge of those. And John and Tom themselves are not lawyers, and they don't really understand all the ins and outs. They didn't tell the new solicitors specifically, oh yes, we barred the entail in 1997, and now Tom is going to be the absolutely entitled beneficiary when I die. They didn't tell them any of that. They just said, look, we've got all this trust stuff. You'll have to get the boxes from the old solicitors. So the new solicitors sent for and received 4 boxes of documents from the old solicitors, along with a 4-page schedule on the front, which identified some documents and collection of documents by an index and a brief description. And what it said, material to this discussion, is it referred to this 1926 vesting deed. And you'll recall that I mentioned this just now, and that was a vesting deed by which one of the earlier barons had, he and the Settled Land Act trustees had vested the property in him for life, but it wasn't a settlement itself, it was just a vesting deed. Anyway, this vesting deed assumed great importance for some reason to these new solicitors. There were other, so even if they hadn't read the 4 boxes of documents, they would have known from the schedule that it was full of trust documents. So what should this new firm have realised at that stage? They've got a box of documents, they're being instructed by the 3rd Baron or the 5th Baron and his son. They should have realised, shouldn't they, that the history of these settlements extended back decades. They had a boxes of documents. What could they conclude from that? There were likely to be a large number of trust documents that they needed to look at. What could they not tell from simply looking at the index? What they couldn't tell was which was the operative trust instrument. The box actually did contain, had they looked at it, if they'd gone in and looked at it, they would have found the 1926 vesting deed that they thought was very important. They would have found the termination of that trust, the deed of discharge from 1962, and they would have found a copy of the operative trust instrument, the 1963 settlement. It didn't, that box didn't contain the 1997 disentailing deed, the one that brought the entailed interest to an end. That was actually still in a fifth box that the old solicitors had failed to send. But they would have, if they'd looked in that box, they would have found the operative trust instrument. So pausing there, it slightly beggars belief that they didn't look in all those boxes, and one wonders at the thought process of taking on board a new client and agreeing to act for them in estate planning purposes at that stage. John hadn't asked about his will at that stage, but just for general purposes of estate planning. What do you do when you've got a new firm, you've got all these boxes? Shouldn't you have read the documents? Shouldn't you have got a report from the old solicitors? Maybe not. Maybe no one is. Maybe the person they had indeed retired, but I don't think they actually tried. So big question as to what should have done, what they should have done. They must have read something because, as I said, they thought the 1926 vesting deed was very important. But I think pausing there, a competent private client solicitor with experience in dealing with trusts and estates, reading the above documents in or after the moment of instruction, should readily have been able to conclude the following: that the old settlement was brought to an end in the 60s, and a new settlement was created in 1963. That's probably the operative settlement, but we need to look at the trust documents to see what's happened since. But none of that happened. So what happened a year or two later, when John and Tom asked the solicitor for IHT mitigation advice, John asked whether he should be making a new will, and the solicitor drafted that will and advised without reading that box of documents or even looking in it. So therefore, without correctly ascertaining which was the operative trust instrument applicable to the settlement, of which they understood that John was a life tenant of a trust, but they failed to ascertain which trust. So what unfortunately happened was that the solicitor thought the vesting deed was itself a settlement. He thought that was the operative settlement. He thought that the settlement was still entailed. So he thought that he needed to advise the testator to make use of the spouse exemption by advising him that he could appoint his, under the trust instrument, this was permitted, he could appoint his interest to his wife under his will, and that therefore, when he died, his wife could claim the benefit of the spouse exemption, and she would be the life tenant. So that was a complete and utter misunderstanding of the true situation. So he failed to appreciate or understand when drafting John's will that in fact what had already happened was that old trust had been brought to an end, and that the situation was that when John died, Tom was going to become absolutely entitled to the trust assets. So he drafted a clause which was null and void, and therefore when John did die, Ben became entitled to, because the trust estate was huge, Tom became entitled to all the assets and huge inheritance tax bill to pay. So because the solicitors drafted in an appropriate will by including in it an appointment of the entailed interest, the family lost the opportunity to make appropriate tax mitigation measures. Now, what is then very difficult to analyse, because it's the loss of a chance situation, is would John have, what would they have advised if they knew the true position, and what advice would the family have taken? So we needn't dwell on this in any great detail, but it was the um, um, just as a postscript out of interest, they would have given appropriate. What we've got an expert to say what evidence would have been, what advice would have been given, and we've also got strong factual evidence to suggest that that advice would have been acted upon, and therefore there would have been a lot of tax saved. So that and hundreds of thousands of pounds of tax just as a result of a very, very simple error and misjudgment in concluding that a particular vesting deed was the operative deed, and failing to appreciate. So a salutary tale in many ways. Now, before we go on to the Rabboni case, I think I'm supposed to allow a little break. Is that right, Helen and Eloise? It's 12:45, and we could have a little break now. So Eloise, Helen, I don't know if you want to, or Will, I don't know if you want to jump in and approve that.
Yeah, that sounds okay to me. Does it to you, Helen? I suppose it has been a little while.
Yeah, absolutely. If we just want to take a couple of minutes, that would be great, and then we'll resume.
Fantastic.
Okay.
Lovely.
Great. Resume
right.
at 12:50 then, yeah?
Sounds good.
Okay.
Cheers.
Okay, my picture seems to have gone. Ah, there we go. Are we back live?
I think so. I don't think it's, yeah.
Okay,
You certainly
I'll
got a
crack
live
on.
on yours, Kate. So yeah,
Good,
carry on.
excellent. Yeah, and my
Lovely.
screen went dark for a bit. So I will crack on and tell you about the Raboni case. So in fact, this is a case that ended up in the tribunal under the name Hall against HMRC. It's a reported decision, and I can provide the details afterwards. And it's a case where better advice could have been given about what Mrs. Raboni wanted to achieve in terms of giving someone a life interest to occupy her property. So it's a case where some perfectly okay will drafting actually led to an unforeseen problem. But now I'm going to tell you about it. You'll never have to make the same mistake. So let me tell you a little bit first about the people involved in this case. So Carolina Raboni was, by all accounts, a lovely person, a widow, a retired cafe proprietor, and the sole owner of a property called 51 Fortis Green in North London. And she lived down the road, 3 doors down. She had a great friend called Rita, who was often visited by her brother, a Mr. Lazzaro Boggia, all these lovely Italian community up in North London somewhere. And he'd come to live with Rita since his divorce. And he struck up a really kind and lovely friendship with Mrs. Raboni, who, after her own husband died and after she became quite frail, he would help her about the place. And we're going back a long time actually to the autumn of 2002, and he began to visit Mrs. Raboni regularly and help her out at home and provide company, etc. And in 2003, Mrs. Raboni made her last will, and she went to see solicitors to do it. And I'll tell you about the clause in a little bit more detail in a moment. But what she did was the clause gave Mr. Boggia a right to occupy this property, but only this property. It didn't give a right to move into a substitute property. And we don't know now what was discussed. It was a long time ago, and we don't know what was discussed with by the particular solicitor. And sadly, I go back to my point about attendance notes. We don't have an in detail account of quite what was discussed and what Mrs. Raboni wanted, other than to give Mr. Boggia a right to occupy her property, 51 Fortis Green, and then to leave the residue of her estate to her 5 Italian nieces and nephews. So she died in 2004, age 92, and Mr. Boggia moved in, and solicitors were instructed to obtain probate and administer the estate. And they assumed that, which was wrong, as it turned out, that's what the case was about, that Mr. Boggia had a full life interest, notwithstanding that there weren't many other assets in the estate. There was only about £10,000 cash. Most of the estate was made up of the property, and there was inheritance tax to pay. And the inheritance tax was about £15,000. So it ate up all the residue. And what the solicitors assumed was that Mr. Boggia's life interest took precedence. And so they told the nieces and nephews, look, we're short on the inheritance tax. What do you want to do? If you sell the property, it will be subject to Mr. Boggia's life interest. Now, that was incorrect advice, but that's what they told the beneficiaries. So the beneficiary says, oh, well, we don't really want to sell the property. We think it will be a good investment to keep it. And so between us, will raise the additional money to pay the inheritance tax. So that's what happened, and Mr. Bodger lived quite a long time after that, and he died in 2017. And then the property was sold for £827,000. And because it was thought that Mr. Bodger had an interest in possession in the trust property, the will trustees therefore thought, obviously, that had to be added to the value of his estate, and there was a £120,000 inheritance tax liability. And the will trustees paid that to HMRC, and then the nieces and nephews jumped up and down, and they said, why have you just paid that inheritance tax to HMRC? You must have been negligent, because surely our aunt would never have wanted a situation where inheritance tax not only had to be paid on her death, but also on Mr. Bodger's death. And the solicitors said, well, that's what happens when somebody has left an interest in possession. They die, it has to be added to their estate, tax has to be paid. But the beneficiaries were adamant that the solicitors had done something wrong. So I became involved when the solicitors said, could you have just a thorough review and an overhaul of everything that has happened and let us know what you think? So I looked at it, and this is the issue that was litigated. It seemed to me that the 120,000 shouldn't have been paid because it was arguable that Mr. Bodger never even had an interest in possession in the estate when Mrs. Raboni died. So let's sort of break that down into pieces. So let me tell you first of all what the actual will said. I give and devise unto my trustee my freehold house at 51 Fortis Green, to sell the same with full power to postpone, etc., etc. Upon trust in equal shares for my 5 nieces and nephews, it sets them all out, provided my trustee shall not sell or dispose of the said freehold house during the lifetime of Mr. Bodger without his consent in writing, to the intent that the same shall be retained as his home for so long as he shall desire without charge, but he being responsible for the outgoings. That, as I said, and this is the rub of the whole thing. Why did the will draftsman let Mr. Bodger only have an interest in this house alone? So it was a very limited right of occupation. If he had let Mr. Bodger have a full life interest that survived the sale of the house and gave him an interest in a substitute property, this problem would never have occurred. So what the litigation was all about was whether the nature of this very limited right was an interest in possession for inheritance tax purposes. And the revenue took the view, yes, entirely correct for that tax to have been paid to HMRC. Of course, he had an interest in possession. He had one identified in that he had a right to occupy identified in the will. She died. He lived in the property till his death. He must have had an interest in possession. And the reason why the case is interesting is because actually this particular point has never been litigated before. And we can solve the conundrum, really, because it sounds like, doesn't it? It sounds like, well, surely he did have a right to occupy the property. The will says he did. But I think what we have to unpack there is, what is an interest in possession? What's the nature of a beneficiary? 5 questions, really. 1, what's an interest in possession? 2, what's the nature of a beneficiary's interest in an unadministered estate? 3, what are the rules governing the administration of estates? 4, which we've looked at already, what was the nature and scope of the clause 3 gift to Mr. Bodger? We've looked at that already, and as I said, it's just the right to occupy alone. Final question, did the action of the executors and the beneficiaries who got together and decided that Mr. Bodger could carry on living there and the house wouldn't be sold, did that somehow confer an interest in possession on Mr. Bodger? So I think it's the 2 initial questions are the key ones. First of all, what is an interest in possession. Now, that's not defined in the taxing statutes, but instead you have to gauge its meaning from a press release from HMRC in 1976, and then more importantly, when it came to be litigated, the House of Lords speeches in Pearson against the IRC in 1981. And without reading any of that out in detail, I'll cut to the chase and go to the definition in its briefest possible form. A person has an interest in possession when they have a present right of present enjoyment or an immediate right to the income or enjoyment of property. So, a right of residence conferred by a trust instrument will, if it confers a present right of present enjoyment, be an interest in possession. So the next question is, at the moment of Mrs. Raboni's death, did Mr. Bodger have a present right to present enjoyment of trust property? And it's the answer to this question, what are a beneficiary's rights in an unadministered estate, that in fact is the really interesting question, and one that props up, certainly for me, surprisingly often in practice. If you are to describe to someone what right does a beneficiary have in an unadministered estate, go back to first principles. Do they have a beneficial or legal ownership of estate assets at the moment of death? No, they don't. They have inchoate rights. They have the right to compel due administration, which comes with a whole bundle of things that they can do to enforce that. In due course, those inchoate rights will hopefully mature into an interest under a will trust, or let's say, for example, they're left the Picasso. If the estate is solvent and the debts can be paid from other assets that don't constitute the Picasso, they will get the Picasso. So there's a key case that deals with all this brilliantly, and that was summarised in a later case a few years later. So if you ever need to know about anything like this, you should go and have a look at, if not my handout that I'm happy to give you later, a case called the Commissioner of Stamp Duties in Livingston, which is a 1965 appeal case. And then afterwards, Re Lee's will trusts. And in that case, Mr. Justice Buckley summarised the principle of the earlier cases. But it's that case that establishes, in no uncertain terms, it's talked about at length, for reasons we don't have time to go into today, precisely what the nature of a beneficiary's interest is in an unadministered estate. So to summarise the points that Mr. Justice Buckley said, because that's much briefer, although my handout does contain the relevant passages from the earlier case. The Livingstone case, Buckley said, establishes the following propositions. 1, the entire ownership of the property comprised in the estate of a deceased person, which remains unadministered, is in the deceased's legal personal representatives for the purposes of administration, without any differentiation between legal and equitable interests. 2, no residuary legatee or person entitled upon intestacy has any proprietary interest in any particular asset comprised in the unadministered estate of the deceased. 3, each such legatee or person so entitled is entitled to a shows in action, that is, a right to require the deceased estate to be duly administered, so he can protect those rights during the course of, because he's entitled to due administration. And 4, which doesn't concern us particularly, each legatee or person so entitled does have a transmissible interest in the estate, so you can assign it to somebody else. So it is a thing, it is a real thing, it is a shows in action. So going back to Mr. Bodger and Mrs. Raboni, what do personal representatives have to do? They have to administer an estate according to law. And that's what Section 25 of the Administration of Estates Act says. And this includes selling specifically devised property to pay the debts and liabilities where the residuary estate is insufficient for that purpose. So in Mr. Bodger's case and case of Mrs. Raboni, what the testatrix inadvertently did was that she only left a very limited right to Mr. Bodger. So because the inheritance tax bill was had exhausted the residue, what the executors would have been within their rights to do would have been to sell the trust property. Mr. Bodger couldn't have done anything about that because they could rightly have said, we need to pay the debts. Mr. Bodger couldn't have said, well, I mean, in practice, the position might have been resolved in a different way rather than have it all litigated. But in law, there was no entitlement for Mr. Bodger to say, I demand that you raise the money to pay the tax so that I can enjoy my interest in possession. And unfortunately, it would have been so much easier if Mr. Bodger had been given a life interest to occupy a substitute property, because then they would have just been able to purchase a slightly cheaper substitute property, paid the tax, and he could have gone on enjoying a full life interest in the estate. So it was a matter of, it was a mistake really that they didn't spot that. And in fact, for Mr. Bodger, life was fine because he did carry on living there for the rest of his life. But the argument that we had with the revenue was that as a matter of law, what happened was that interest that Mr. Bodger was granted under the will never matured into an actual right to occupy the house because of the estate was too illiquid for the inheritance tax to have been paid in any other way. Now, as a matter of fact, what the parties did was that they raised the money and Mr. Bodger carried on living there. But what I argued before the tribunal and what was accepted was that the true nature of what Mr. Bodger then did for the next 20 years was he was occupying as a licensee with the permission of the beneficiaries, so that when he died, he didn't have an interest in possession and no further inheritance tax was due. And I've spent time talking about that case. I think it's a very interesting case and requires you to drill down into the detail of when a beneficiary acquires an interest in an estate or a beneficial interest in an estate. But it's also a salutary lesson for the person drafting the will to start with, because I think the key take-home point is you need very much to understand if a testator comes along and says, I'm really desperate for X to have to be able to reside in this property after I die. There are two key things that you need to do. You need to ensure that there is enough liquidity in the rest of the estate to enable the tax to be paid so that recourse doesn't have to be had to the property. And if recourse might have to be had to the property, then you would have to advise the testator that a very limited right of occupation, therefore, would be under severe threat and wouldn't survive the process of administration, because it would have in effect never come into existence. So in those circumstances, you would have to explain to the testator, well, look, you've only given a very limited right to occupy. This is the consequence it could have. Is that what you want? And you might find that most testators would say, oh, no, yes, I do want a right in a substitute property as well. Or you might get the answer that, no, it's just this property and none other. But at least you'd have asked the question. So in this particular case, although the will draftsman drafted a perfectly acceptable will from a drafting perspective, he didn't anticipate the lack of liquidity in the estate, and he didn't anticipate the consequence of what that would be. I suspect in practice this has happened more than once, but it's the first time, and the parties will reach some sort of accommodation. But it's the first time it's been before the courts on precisely this point. So it's certainly one to watch for. And really interestingly, although the Revenue put up a staunch fight and had a number of arguments to try to counter the submissions that we were making for the executors and will trustees. They decided not to try to appeal it. So at the moment, this is the only decision bang on this point. Okay, it's 10 past 1, and I do want to allow a few minutes for some questions. So let me just briefly touch on the issues that the sort of tidying up issues, because I think there's I did want to say something about capacity as well. Now, ascertaining testamentary capacity, we all know how important this is. The protocol I mentioned earlier on has some good paragraphs on it. It's got the quote from Kenwood and Adams, the golden rule that we all know about, and I will just tell you what that is. That was the case in which Mr. Justice Templeman, as he then was, stated, in the case of an aged testator or a testator who has suffered a serious illness, there is one golden rule which should always be observed. However straightforward matters may appear, and however difficult or tactless it may be to suggest that precautions be taken, the making of a will by such a testator ought to be witnessed or approved by a medical practitioner who satisfies himself of the capacity and understanding of the testator and records and preserves his examination and findings. We all know as well that the golden rule is not a rule of law, it's simply a statement of good practice. So what can we do? Because there are still far too many cases where the attendance notes say, I'm an experienced probate practitioner. I've known Mrs. Jones for 20 years and I've got 25 years experience, and she came to see me, and I'm convinced she went through, she understood fully what she was doing. And a really good attendance note would obviously say, well, I know what the test for capacity is, and I know that she needs to understand the nature of, she needs to know she's making a will, she needs to understand the extent of the property which she's disposing of, she needs to comprehend and appreciate the claims that she might have on her estate, and she mustn't be suffering from any disorder of the mind or delusion that prevents a rational consideration of all these things. So the really good attendance note will have an eye on the test for capacity, the Banks and Goodfellow test, and will address those issues in the attendance note. And perfectly reasonable on that footing to decide not to make the testator have the embarrassment or the delay or the expense of going off to get some medical advice and a medical opinion. But it has occurred to me, and I'd be really interested if you wanted to pop something in the Q&A box. Over the years, it's occurred to me. I do wonder whether there is, and perhaps some of you are doing this, whether there is a way in which a firm can strike up a link with a medical professional, so that a medico-legal assessment can be introduced into a firm's will-making processes, so that, for example, it's not a subject that has to be dealt with embarrassment or, oh no, we've got to get over that golden rule hurdle, as to whether, if a firm can strike up a relationship with some medical professionals, whether this could be all part and parcel of a smoother process built into your charging structure. Now, because I'm not a solicitor, I'm just counsel, and I just see these problems as they emerge. I don't know whether that is commercially sensible, feasible, or whether it's even desirable. But it struck me that one of the issues is that there's not often a mechanism in place whereby it's sort of pretty standard that the firm will say, yeah, Mrs. Jones, delighted to see you. Of course you have capacity, but it's part of our protocol, and don't worry, it's all built into the charges. It's part of our protocol for you to see X. He'll ask you some questions, and this is to protect you, etc., etc. So I'd be really interested to know if anybody is doing anything like that, or if anybody thinks that's a good or a bad idea, or not commercially feasible. Because it struck me that would be one way to manage this code of practice, this statement of good practice, if one could streamline it into a private client process. I mentioned earlier on, we haven't got too much time left, but I mentioned earlier on having a discussion with the stubborn client who wants to leave everything to the RSPCA and doesn't want to make provision for his minor children or his dependent spouse. Obviously, the protocol suggests standard advice on the 75 Act to be provided as part of the will drafting retainer. And obviously one endorses that. But again, how interactive are you being with that? Is that something that you do as standard? Do you have any problems in those areas? Is that something you've been able to navigate pretty well in your practice? Because it's surprising, isn't it, the number of people who think they can make a will in exactly the terms that they want to. And of course they can, but there are post-death challenges in view. So I'm always surprised by, you ask someone on the street, can you make a will to whomever you, leaving your property to whomever you want? The reaction is, yeah, of course you can. So most people haven't heard of the 1975 Act, and most people, I think I would say, don't know that there are these potential applicants who can make applications under the Act. So from my point of view, I think there's still work to be done on what testators should know, and I come across far too many cases where that advice simply hasn't been given, or if it has been dealt with on quite a cursory level. So again, best practice on that would be to have a really robust policy on future 75 Act claims, and bringing that to the attention of clients and helping them manage it as part of the will drafting retainer. Finally, I'm quite excited by something that, and you may already all be members or know much more about it than I do, but I'm quite excited by the new group that's been formed amongst solicitors, which I think was the brainchild of someone at Thompson, Snell and Passmore, called the National Association of Independent Administrators. So this, for those that don't know, is a new association that's been formed to bring together contentious and non-contentious lawyers, specialising in providing independent administration services. So obviously this is when something has already gone wrong. We've already got the post-death challenge of one sort or another, and an independent administrator needs to be appointed. We've all had cases, I'm sure, where I certainly have, where independent administrators have either come along, or I'm part of recommending them under a Section 50 removal of an executor application, and we've brought along our neutral third-party administrator who's going to step in and rescue the situation. But we all know that once those people have been appointed, that doesn't make everything in the garden rosy. They can have tremendous difficulties in dealing with difficult beneficiaries. They can have tremendous difficulties in dealing with, even if it's not just a question of administration, if there's an active problem like a challenge to the will by somebody who's been replaced as the administrator. We all know that those sorts of people can have tremendous problems in dealing with the estates. And I think that what this association, I think one of the prime reasons for its existence is to get engagement from the bar, the judiciary, the government on improving the way independent administrators are appointed and supported once they're appointed. So I'm really excited to see that is now a reality, and I for one would be delighted to speak and get involved in that. I'm not quite sure how many members it's got yet. I think quite a few. But it is a rapid growth area. It's a complex area of probate, and it is a rapid growth area, as I said, because there are the number of challenges to wills and the number of difficulties in contested estates is growing year on year. So I'm looking forward to being part of this thriving community, and just wanted to bring it to your attention if you weren't already aware of it. And I think it's probably about time for me to stop talking.
Well, that was great. Thank you so much, Kate. Fantastic. I'm going to hope there's some questions after all that. Surely.
Even if to share, share experience.
Exactly. Yeah.
Tell us a tale of woe and how it's turned out. I mean, look, if there's no questions now, I'm obviously if anyone wants to follow that up, either with a personal email to me or to the society, I'd be very willing to do that. The handouts I've got some detailed handouts on the case, the sort of case studies I mentioned. So I'm quite happy to share those for those that want it. And if I'm allowed to, I don't see why I wouldn't be, because it's just a personal PDF. My version of what I downloaded on the Law Society Wills and Inheritance Protocol. But as I said, I think you can, if I'm allowed to share that, I will. But I think it's published as well. So if anyone,
you can share.
I think I can share, can't I? I don't think there's any copyright problems with any of that.
No.
I mean, I'm not sure whether it's still downloadable off the internet, but I think I can share that.
Feel free. The Q&A function isn't working for me. I'm not sure if others are having the same problem. So if you want to do a raise a hand, I'm just having a look to see who sent that message. Ella, can you do a raise a hand function at all? And then we can, there we go. And then I think we can unmute your mic, can't we, Helen? Is that right? Helen's typing. So, the plot thickens, right? I mean, if there's any consolation, my team's just crashed now to come back in again. So it's probably about right.
Sorry, all. We're slight technical issues. I can see your hand is raised, Ella. I'm struggling to unmute you, which is unusual because normally we can. Would it be possible to use the chat function for questions? I'm not quite sure why it's not working properly, but please do feel free to put them in the chat box, and we can certainly pick them up that way. In the meantime, we'll continue to try and figure out the issues with the microphones. If you do intend to ask a question, if you could raise your hand just to let us know that you are kind of doing that and writing, so we don't cut you off. But apologies, I'm not quite sure what the issue is, but please do use the chat box for any questions.
And do feedback on the fact that whether you found it helpful or unhelpful that I didn't have PowerPoint today. I'm sometimes I like to talk with PowerPoint, sometimes I don't. But I'm very much aware that some listeners, viewers may like that, some may not. So do feedback if you found that either helpful or you would have preferred to have the slides as we went along. I think it's always useful for speakers to know that, because I think sometimes the answer isn't entirely obvious. The downside, of course, is that you have had to look at this. Well, actually, I tidied it. So I was going to.
I didn't know if that was a background, Kate, or if that is actually
no, that is actually my room. So that is actually my room in Chambers.
Brilliant. I mean, most of
So
us have to use an AI generated office to make it look fascinating and interesting.
yeah,
Or they
all
just blur
the
the background, which is what I've done, obviously, because my room isn't that fascinating either. So, but that's, I mean, that's great. And there's certainly a lot of books there, isn't there?
a lot of books, a lot of papers. Although, you know, we do try not to be too tree hungry these days. So
Yeah.
increasingly one's getting used to the PDF bundles have got much better court wise. You know,
Okay.
if you're doing online hearings, we've the PDF bundles are now very easy to manage. And I have 2 screens now. Perhaps you do too.
Yeah, 2 screens. Yeah,
Yeah.
it seems standard these days. Although, yeah, I think I just have it just simply because I like it, and I can put things that I don't care as much about on one screen, things I
Yeah.
care more about on the other. But yeah, no, perhaps not too many reams of PDFs on my screens at the moment. That's for sure. Almost one screen constantly on LinkedIn is what I always seem to find, and then the other doing everything else.
Yeah.
Seem to always
Oh,
have
I
to
got
keep
a
one eye on
question.
LinkedIn these days. Oh, here we go.
Got a question.
You have a question now, Kate.
Excellent. In a situation where attendance notes are not available, for example, the deceased made an at-home will, and you are approached by the deceased executor who explains they made this urgently before the deceased passed away, what would you advise or do? So I suppose that presupposes that one's involved in a situation where one wants to know what was in the what was in the testator's mind. I think obviously we've got recourse to the Larkin-Nugas setup where you can write to the solicitor who took the will, and that there's some standard forms of Larkin-Nugas requests, but typically a dozen different types of question where you would ask the will maker, the will drafter, what the circumstances were in which the will was made. So there is usually a way to engage with the will draftsman, and that you would certainly want to do that if you didn't have attendance notes available. There will obviously be you have to think carefully before you make a Larkin-Nugas request, and you'd have to understand whether the reasons why it's wanted, but that would be the first and obvious thing you could do to try to understand the context in which the will was made. The other thing, of course, if you're approaching a litigation situation, is to approach the witnesses to the wills as well, just to see what their level of engagement was, and whether obviously that's a test of validity anyway, to find out whether what's on the face of the will is actually the reality. So 2 people in the same room as the testator, watching the testator put their signature on the will and then signing one after the other themselves. But yeah, situations of urgency can be very difficult, because solicitors will be mindful where there's a situation of severe ill health, for example, that they will need to act with speed in helping a testator make the will they want to make. But obviously that's not an excuse for not taking an attendance note. So even in cases of urgency, you would perhaps, some solicitors will obviously make home visits. In other cases, and this is more often in the litigation context, what you've got is an elderly testator who's unwell, but who does manage to go to the solicitor's office to give instructions, but then the will is drafted and it's sent to the testator at home with instructions on valid execution, and then you don't actually know the precise circumstances in which the will then came to be executed, and whether undue influence was brought to bear. So there, I mean, that's the protocol says something about that, where you draft a will but then you send it to the testator for execution at home. But obviously that's not the ideal. If possible, you'd want the testator back in your office to witness it, or you would want to make a home visit. And again, that's price dependent, isn't it? Hope that answers that question.
Certainly seemed thorough to me, Kate. That's great. Thank you so much for the question there, Ella. That's great. Any more, or how are we doing for time? I suppose is the next thing, isn't it?
Yeah, I think we're about there, aren't we?
Might be.
So yeah, as I said, any other questions, or if you found listening to me without looking at notes useful, or you'd prefer the notes, do let me know. I'm very mindful that I want the experience to be as useful as possible for you, the listeners.
Great stuff. So yeah, I think we're there. Helen, do you have anything that you wanted to say to sort of round it out, or bring us to a conclusion,
just,
I suppose?
Apologies again for those technical issues with the questions. And if it's all right with you, Kate, if anyone did have anything they wanted to follow up on, please send it to me and I can forward that on to her. As Will mentioned earlier in the session, please do fill out the feedback form. You can use that to share views on using the slides or not, and we will circulate those to you with the recording as well. So thank you so much, Kate. Thank you, Will and Chadwick Knott, for your sponsorship. And we hope you all have a fantastic day.
Lovely stuff.
Thank you.
Thanks,
Bye-bye.
everybody. Lovely.
Thank
All
you.
the best. Cheers.